that okay? You'll be ready to go? Good evening and welcome everybody to the planning meeting, which is being held remotely. We are recording the meeting and the recording will be available on the Council's website following the meeting. This meeting is being streamed live on the Council's YouTube channel and the link is provided on the Council's website. Please note that any comments posted on the chat feed of the Council's YouTube channel during the recording of this meeting will not be monitored by the Council. All mobile devices should be switched off or set to silent so that the meeting is not interrupted by ringtones. Please switch your profile to mute unless you are speaking. Procedure items. For each item, the planning officer will present their report. The planning officer will read out any statements that have been given that may be pertinent to that planning application. The chair will then invite those who have indicated and given previous notice that they wish to address the committee to do so. Each person will be invited to join the meeting via Zoom and will have 3 minutes to give their views. Councillors will have 5 minutes. Once all comments have been given the meeting, the chair will invite the members of the committee to discuss the application and reach a decision. Thank you. Okay, item agenda 1. Do we have any apologies for absence?
No, Chairman, there are no apologies.
Thank you. Declarations of interest. Councillors, do we have any declarations of interest? No, thank you. Minutes from the last agenda. So this is minutes from the 16th of March. Could we please unmute councillors so I can take a vote on this, please? I'll come to Councillor McGeorge.
In favour.
Thank you. I come to Councillor Morris.
Agree.
Councillor Turner.
In favour.
Councillor Rimmer.
In favour.
Councillor Kettle.
In favour.
Councillor Darren.
In favour.
Thank you. And with that, we can move on now to item agenda 4. We're not doing the press now, though, are we? Doing that after? Yeah, that's what I'm saying. Yeah, I'll now hand you over to our officers to have the planning application report, which will outline the circumstances for all of the applications as outlined previously. Thank you.
This evening's committee is here to assess planning applications for 9 separate planning units that have been carved out of one previous planning unit that had the lawful planning use as vacant land or agricultural land. As the applications are separate and freestanding, there are variations between them that will be highlighted to the committee. Part 1 of this meeting will consist of the policy assessment of the application, with the personal circumstances being discussed in Part 2. The personal circumstances will of course vary for each case. Essentially, within the main policy content, the matters to be considered by the committee are very similar, with only the application for plot 11 varying from this. This is because the land remains undeveloped. As a result, the description will be proposed for plot 11, and the matter over intentional development in the greenbelt, which I'll go over later, will not apply to plot 11. At this point, I would refer the committee to the update sheet that was distributed today for plot 11, which is on agenda 13. The land in question is situated on the southern side of Hofields Drive between that road and the A127. As stated, the land was previously vacant. In planning terms, it is lawful either as vacant or as agricultural use. The land is designated greenbelt and also carries the plotlands designation 2 within the local plan. So the background to this case, to provide some background information to this application, on the weekends of the 28th and the 29th of November, the council received reports that development had commenced on the land. An enforcement notice was served in respect of the hard standing, fencing and partitioning of the land. The council also sought an injunction from the High Court and was successful in this being granted. A planning application was submitted over the same weekend and processed and became legally valid from the 1st of December 2020. Despite the application, despite the enforcement notice being served and the injunction being granted, development continued on the site and included the arrival of caravans throughout the beginning of December. Further enforcement notices were served on the 4th of December in relation to the caravans, including their residential occupation. It was not possible to serve enforcement notices in respect of the caravans on the weekend of the 28th and 29th of November, as the enforcement powers available to the council in law cannot preempt suspected planning breaches. Owing to the multiple High Court challenges and appeals, the occupiers of the land had until Monday, the 22nd of March, to leave the land in order to comply with the terms of the notice. The enforcement notices themselves are under appeal, but this application is independent from that appeal and from those enforcement notices. So we'll go through each plot now. So if my colleague could put up the map for plot 1. So essentially, the committee may notice that there isn't an application for plot 2. That's because it's actually comes under plot 1. For some reason, the map isn't coming up there, but the plot numbers are in an anti-clockwise. Oh, here we go. So this is actually plot 3. That's on the map here, and just to the north of that is plot 1. So beneath the red area, that's plot 4, and so on in an anti-clockwise direction. Now, at the very southern part of that map, the 2 plots there are undeveloped. That's plots 6 and 11. We have not received a planning application for plot 6, but we have received one for plot 11, and that relates to the update sheet that I just referred to. Okay, so unless otherwise stated, all the points that I'll go through apply to all 9 applications. Okay, so the principle of development with the Greenbelt. The framework currently states that development is only acceptable in the Greenbelt under certain circumstances, for example, agriculture, forestry, virtual like-for-like replacement structures, etc. The guidance states that inappropriate development is by definition harmful to the Greenbelt and should not be approved except in very special circumstances. At present, the development has the effect of introducing a built form and change of use of the land for the stationing of mobile homes for traveller pitches and associated fencing, cesspit and hard standing available to the same family units. As the land originally was previously undeveloped, so free of built form, it is clear that harm has occurred to the Greenbelt by reason of definitional harm by reduction of openness. Recent appeal decisions within the Basildon Council area reaffirm that proposals that fall outside of the permissible purposes of land use within the Greenbelt, as set out in the MPPF, are inappropriate, and this includes applications for travellers' pitches. I would refer the committee to the appendix in the agenda for that recent appeal decision that we've allocated a lot of weight to in assessing this application. So an essential characteristic of the Greenbelt is openness, which the council interprets as the sense of freedom from inappropriate development. Openness can be affected whether development is prominently located or not. The mobile homes occupy land that was previously vacant and undeveloped land within the Greenbelt. This site, however, together with other sites, forms part of a wider area of undeveloped land. The site now comprises hard standing to accommodate the introduction of the unauthorised mobile homes, except plot 11, of course, which remains undeveloped. The cumulative impact of mobile homes onto the site is pronounced and represents significant visual intrusion that can be clearly seen from wide advantages and from all surrounding aspects of the site, which together with the formation of hard standing represents an urbanisation of the site. therefore contributing to the reduction of openness of the area. Accordingly, the use of the land for the residential occupation of stationed mobile homes is inappropriate developments in the Greenbelt, and you can see that from the aerial photographs, looking at the field, how it used to look before compared to how it looks today. A survey undertaken in 2015 indicated that a ponded area of land, formerly known as 5 Acres Farm, supported a population of great crested newts. Great crested newts are a European protected species, and as such, it's an offence to disturb these species. They are afforded protection under the Wildlife and Countryside Act 1981. However, apart from Plot 11, the works were unauthorised. Irreversible harm may have occurred, which undermines the council's policies to protect biodiversity within the borough. Indeed, a criminal offence may have even been committed given the protected status of the species. The council is aware that the occupiers claim traveller status for the purposes of planning policy as defined in the planning policy for traveller sites, known as the PPTS, as outlined in background papers submitted. However, regardless of this, even if the council were to accept the traveller status of the applicants for planning purposes, the reasons outlined above, the development constitutes inappropriate development within the Greenbelt. As outlined in the agenda report, the council can demonstrate a 5-year housing supply plan under the emerging local plan. Whilst these emerging policies carry objections, it does, however, serve to indicate that the council is attempting to and considers it can meet its needs in this respect through the plan-led process. If approved, this application, in conjunction with other land adjacent applications for traveller pitches, together with the large number of other unauthorised traveller pitches in the locality along this part of Hofields Drive, and indeed nearby Hofields Avenue, results in a large ratio of traveller pitches compared to the settled residential housing units. Policy C from the PPTS states that applications for traveller pitches in rural areas and the countryside, planning authorities in those circumstances should ensure that the scale of such sites does not dominate the nearest settled community. The council considers that in this instance, given the number of traveller pitches compared to the settled community on that ratio, there would in fact be domination. Although there is the option for the committee to grant temporary planning permission, even on a temporary basis, significant harm would still occur to the Greenbelt. On that basis, we do not recommend, the officers of the council do not recommend that temporary planning permission should be granted. It is agreed by the council that there are no highway matters of concern, even though there would be a slight increase in traffic egressing onto the A127 nearby. That's confirmed by our highway consultees at Essex County Council. And in terms of intentional development in the Greenbelt, this excludes Plot 11, as I said, because it is undeveloped at present. It is clear that the remaining 8 applications, the applicant was aware that planning permission was required for this development, but they continue to proceed to occupy the site in any event, given that the council acknowledged the planning application on the 1st of December 2020, just 1 working day after the commencement of extensive development on the weekend of the 28th and the 29th of November 2020. The fact that further enforcement and stop notices were served on the site on the 4th of December 2020, and the works even then continued, even in defiance of a court order, which took into account the best interests of the children, the personal circumstances of the occupiers and the Equalities Act of 2010, as well as the pandemic, further development was recorded by officers of the council. Intentional development continued, not just against planning control, but in flagrant open defiance of court orders of the most severe kind in what has occurred on this land. And this is contrary to the written ministerial statements that the council must accord weight to and come into its decision. The planning balance is considered first on the basis that the applicant has traveller status for the purposes of applying the PPTS. The proposal represents inappropriate development in the greenbelt that is harmful by definition and therefore contrary in its aims and objectives, and significant weight is attached to this harm. The proposal would result in the loss of openness in the greenbelt and encroach into the countryside. This is particularly evident in the development leading to the coalescence of the scattered built form of this part of the greenbelt. It is considered this would seriously undermine the purposes of the greenbelt, conflicting with two of the purposes of its designation. The considerations in favour of the development have been set out above. These can be summarised as the best interests of the child, the personal needs for sites, and the lack of a 5-year supply, including the failure of policy to provide sites over many years, in tandem with the uncertainty of the available of future supply. However, owing to the serious greenbelt harm arising, as set out above, together with the nature of the development as intentional, unauthorised development of the site, those benefits are not such that they clearly outweigh the harms identified. Accordingly, the necessary case of very special circumstances for development in the greenbelt are not made out. In any event, the Council's position is that it can demonstrate 5 years of supply and that further weakens the merits of the application. And that's it from me for part 1.
Thank you. I think, Martin, you've also got some written statements to read out for the committee. Oh, is Charles doing that? Yeah. Can we go to Charles then, please? Next, thank you.
Thank you. So we have one submission from Councillor Jeffrey. He writes, I object to the above planning applications on the following grounds. Paragraph 145 of the MPPF states, a local planning authority should regard the construction of new buildings as inappropriate in the Greenbelt. The development does not satisfy any of the exceptions which are set out in the MPPF guidance and causes significant damage to the openness of the Greenbelt. The applications reduce the openness of the Greenbelt and have caused significant damage to the local environment. Policy GB1 of the Emerging Local Plan states, the Council will continue to protect the permanence and openness of land designated as Greenbelt. Development within the Greenbelt will only be permitted in very special circumstances, if it is not inappropriate or it is in accordance with an adopted neighbourhood plan. The development is not under very special circumstances and is inappropriate due to its location within the Greenbelt, and by approving the application, it will not be protecting the permanence and openness of the land designated as Greenbelt. A burden on the road network, more specifically road access and highway safety for the adjacent avenue and the community who use it, will be made worse. Furthermore, due to the location of the applications and where it is sited, issues of drainage are a concern, especially with a large amount of rainfall. There is no natural location for the water to go to other than the road, creating access problems for the surrounding area. Thank you.
Thank you. We'll now go to those who have indicated from the public who are wishing to speak. Yeah. Do you want to clarify that?
Right, I understand we've got Mr. Carruthers, Stuart Carruthers, who is speaking as an agent. If he can just turn his camera and his microphone on, please, when he's connected. Can you hear us, Mr. Carruthers? If you can just indicate you can hear us and turn off your mute, I will unmute you.
I should be unmuted.
You are, Mr. Carruthers. Can we just be clear before obviously you put your submission forward, are you going to be speaking about any personal circumstances? In which case, if you are, we will have to go into part 2.
No, I'm not.
I understand we've got Mr. Carruthers, Stuart Carruthers, who is speaking as an agent. I think you've got your YouTube on, haven't you, Mr. Carruthers?
I'm just shutting down that side of it. Okay.
Sorry, so we're confirming that you're not talking about any personal circumstances in your submission. Just indicate you can hear us. Turn your
Yes, I can.
Turn off your mute. I will unmute. Have you turned off your YouTube, Mr. Carruthers? Because I think we're getting both
Just turned off my. I have just turned off YouTube.
Right. Okay. Speaking about any personal circumstances, in which case, if you are, we will have to go to part 2.
No, I'm not.
You've got your YouTube on.
No, I don't.
That's it. It's off. Right. Okay. So we're just confirming you're not going to speak on any personal circumstances.
Hello.
So hello. So the chairman will allow you. Are you going to speak individually on applications? You're frozen. We seem to have lost Mr. Carruthers. We just wait a couple of moments, try and get him back. Oh, you're back with us, Mr. Carruthers?
Yes, I am.
Okay, right. So the procedure is, are you going to be speaking on the individual applications, in which case you have 3 minutes on each, or are you just going to speak to all of them at one point? If we can just be clear, please.
I'm going to speak to them all. I'm going to make a very brief reference to the individual circumstances.
We can't
talk about circumstances in part 1. We'd have to bring you into part 2 of the meeting if you're going to be talking about personal circumstances.
In which case, it's probably easiest if we go and if I make my submission as part
2. Yeah, no problem. Okay, so I'm going to just mute you. We're just going to continue with the meeting to actually exclude the public and press, but we'll take you into the meeting to allow you to make submission.
Yeah,
then.
Can I? Because I've turned off YouTube. Can I watch on this one?
Yeah, we'll keep you in the meeting now because we're going into
Thank you
part
very
2. Yeah, we'll keep you in the meeting.
Okay, members, therefore we need to go to item agenda 4. We're going to vote on the exclusion of the public and press, so we can go into special circumstances. If councillors can be unmuted, please, so I can take the vote. And I will go to, yeah, you should be able to unmute now, please. Right, and I will go to Councillor McGeorge first.
In favour.
Thank you. I will now come to Councillor Turner.
Yeah, 4.
Councillor Morris.
Agree.
Come to Councillor Rimmer.
Thank you. They took a while to unmute me there. I'm voting for.
Councillor Kettle. Councillor Kettle, if you could please unmute yourself so you can vote to go into part 2.
In favour.
Thank you. And finally, Councillor Adaran.
In favour.
And I vote in favour. If we could now take it into part 2, please, and stop before. I have an announcement I have to read before we turn off the cameras. I want to make the public watching this meeting aware that as we have resolved to move into part 2, the live stream of the meeting will now be turned off. When the committee comes back into the public session, the YouTube live stream will be switched back on, but will appear as a new meeting. Therefore, you may need to refresh your screen and scroll down the page to find it. Thank you. At this point, can we please then ensure the recording